All right, we are live on Facebook, and I'm now going, I mean, not on Facebook, on YouTube, and I'm now going to let everybody in. So everybody smile. All right, we are live on Facebook, and I'm now going, I'm not on Facebook, on YouTube, and I'm now going to let everybody in. So everybody smile. I have another program I've been running here. All right, we are live on Facebook, and I'm now going on YouTube, and I'm now going to let everybody in. So everybody smile. I have another program. There we go. Welcome everybody. Sorry, a little tech challenge here with YouTube co-broadcasting here. We are live on YouTube. We are going to wait for everybody to arrive. We see you all coming, and we are recording. So welcome. But we just opened, so we'll let people come into the Zoom webinar. If you're just arriving, you have arrived at the Renters Alliance Renter Town Hall. We've just opened the doors, so people are just coming in. So thank you for your patience, but you found the right place. Welcome, everyone. If you're just signing on, we're just allowing folks to come in at will. Take a few minutes. Just getting started here, letting people come in. And Chris?
Good evening, one and all.
Hey, Chris.
Hello, Rosie. How you doing?
Okay.
Hello, Ken.
Hi, Chris.
And that's Frank Vitale from Legal Aid.
And Frank, we've met. How are you this evening?
Doing well, Chris. How about you?
Fine, thank you. And thank you and all your folks for the good work that you're doing.
Of course. Thanks.
Just letting everybody come in. We'll wait another minute or so, and then we'll get started. This is the Renters Alliance Renter Town Hall. We're about to get started in just a few seconds. You found the right place. Okay, Good evening, everyone. This is Matt Losak, the Executive Director and co-founder of the Montgomery County Renters Alliance, with my colleague and Vice Chair of the Renters Alliance Board of Directors, Chris Perry. I am joined with Frank Vitale, who's the lead attorney with the Maryland Legal Aid Society here in Montgomery County. Keen Nichols, who is a supervisor with code enforcement, and Rosie McRae Moody, who is masquerading as Ken Nichols, will change her name shortly, and Deputy Director Frank Demaray, who is juggling multiple tasks, but listening in, and will join in toward the end of the conversation. And we're expecting, hopefully, John Marshall, if he's not in court, defending a renter right now, and hopefully he'll be able to join us from the Homeless Persons Representation Project. So a couple of things. We are in an eviction crisis, as you all know. Montgomery County has projected anywhere from between 14,000 to 30,000 evictions over the next several months. We have seen in the last 3 weeks, and Frank Vitale, correct me if I'm wrong, but I think we're talking about 4,000 to 5,000 filings for eviction in Montgomery County courts. Is that about right?
I don't have data on the actual filings that are being like the new ones, but up until the last week, the end of last week, we were looking at nearly 3,000 cases actually happening per week.
Right, 3,000 a week.
Right.
So now we're talking, several thousand filings. Now, not all of them result in evictions. A majority of them are dismissed because there's backlogs, people have caught up with their rent, and because of the 2 eviction orders that are still in place. The first one is the governor's order, which provides an affirmative defense, that is a reason to defend yourself in court for failure to pay rent, and the Centers for Disease Control order, which provides the same protection. However, other types of evictions that our friend and colleague and lawyer Frank Vitale can go into when he gives his remarks, but it doesn't protect us from all evictions. It is not a moratorium. There is no stoppage of completely on evictions. There are evictions going on. We are providing through the county, Montgomery County, a rent relief program of up to $12,000 for eligible renters, and I'll put that link in the chat. And if you are in arrears, or you have received an eviction summons from court or a notice to vacate from your landlord or your landlord's attorney threatening to evict you if you don't pay your rent, and you have not applied for this program, please do so. These funds are federal funds that come through the state and the counties, and they're available for this purpose. We are here to help. We're the Renters Alliance. We are the first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. We were established in 2010 at the recommendation of the Tenants Work Group that said there needed to be an independent nonprofit organized voice for renters in public affairs. So here we are. We are an alliance of more than 30 nonprofit, political, religious, civic organizations, and tenants associations, and thousands of tenants across Montgomery County. And we are also a co-founder of Renters United Maryland, which is a similar coalition of organizations statewide that advocates for renter protection legislation in Annapolis during the Maryland General Assembly, and also protects renters against legislation hostile to renters' rights. So with that, I'm very, very pleased to have with us Frank Vitale, who is an experienced attorney with Maryland Legal Aid and has been doing yeoman's work with Legal Aid, protecting renters, thousands of renters who are facing eviction in Montgomery County courts. So Frank, would you like to take it away and tell us a little bit about yourself before you get started?
Sure. Thanks, Matt. So like Matt said, my name is Frank Vitale. I am the supervising attorney for the Montgomery County Office of Maryland Legal Aid. Maryland Legal Aid is a private nonprofit law firm. We are not part of the government. We are not the public defender. We are our own separate nonprofit, funded partially by some state and federal grants, partially by your retainers, and partially by by other sources of grants. But the important thing to note is we are free. So as long as somebody qualifies and they are eligible for services, you will never have to pay us a dime. So we handle a wide range of civil cases. We serve thousands and thousands of Marylanders every single year across the state. We are a statewide organization with a statewide breadth of expertise. So I have been at Legal Aid now for 6 years. I've been doing housing pretty much my entire time. It is, if I have a specialty, it is my specialty. Part of what we've been doing during the pandemic is a program where we offer representation in court. Now, I'll get back to that a little bit. I'll get back to the details of that in a little bit. But just so you know, we are a regular law firm. We just get paid a little bit less. And we take cases, we represent clients just like every other lawyer. We're not legal aid lawyers. We are lawyers who work for legal aid. So I want to go over a couple things here because I think it's important for all renters and all tenants in the county to know, and across the state, if anybody has called it from outside of Montgomery County. Just to be clear, I will be focusing on Montgomery County cases. Landlord-tenant court can be very local, very regional, both in the laws themselves. Montgomery County Code has some provisions that aren't necessarily statewide, as well as how cases are arranged, where they're heard, how they're scheduled, and so on. So we are currently facing sort of the, I wouldn't call it the tail end, but the end of the beginning of the eviction crisis in landlord-tenant court. Now, I will be focusing primarily on judicial evictions today. I'll talk a little bit about non-judicial evictions and why they're illegal, but I want to focus on court because that's probably what most of you are interested in hearing about. Up until last week, we were hearing, the court was hearing somewhere in the neighborhood of 2,500 to 3,000 cases every week. This was 2 to 3 courtrooms every single day in Silver Spring all day. So that has since changed. So starting this week, the cases have moved from Silver Spring back to Rockville. So now Rockville has 2 days a week of failure to pay rent cases and 1 day a week of non-failure to pay rent landlord-tenant cases. I'll go through the differences between them in a second. What that means is that if you had a case that was originally set in Silver Spring, it is likely to have been moved to Rockville if it was continued. And for the foreseeable future, all cases will be held in Rockville. This is a return to normalcy for the courts. 5 days a week was a very long time, a very difficult time for the court, for us, for tenants, for everybody. So the court has moved us back to a normal schedule now that they have gotten through their backlog. The cases that we're starting to see now in failure to pay rent matters are primarily, today was all March and April. So we are starting to see they've caught up really. So they got through their backlog. They got through last summer and the fall and the winter and the spring. And now we are looking at recent cases. That does mean a couple different things. It means that dismissals are a little bit less common because they're more recent matters. It also means that the numbers are a little bit lower, which is also good. So what is an eviction? What is necessary for an eviction to occur? I mentioned the difference between a judicial eviction and a non-judicial eviction. A non-judicial eviction is also called a self-help eviction, where the landlord comes in and changes the locks. Now, I will tell you this, and I'm sure Rosie will tell you this, and Frank may tell you this, Matt will tell you this, that is illegal. It is not allowed in Maryland. So if you come home and somebody has locked the doors on you, your best bet is not to call me, because all I'll be able to do is file a civil case and get you in front of a judge who might listen to you in 2 months. I will defer to my friends at the county on the proper people to call for that, but I'm going to focus on judicial evictions, which means a case is filed, it is heard, somebody wins or loses, and then if the landlord wins, they will be able to get an eviction down the line. So when a landlord gets a judgment for possession, 9 times out of 10, it's just for possession. It's not actually for any money. The judge may say, we find that this is owed, or we find that is owed. Most of the time, that's really just for the purposes of redeeming the property. to pay and stay. What a judgment for possession in a failure to pay rent case really is an order to either pay this much or leave. So, assuming that the tenant is unable, or in some cases unwilling, to make that payment, a landlord would be able to get a writ for possession 4 days after judgment, after which time they will be able to call the sheriff to schedule an eviction. So there's multiple steps. So if you get a notice from your landlord, you're not going to be coming home from work to see your stuff on the lawn the next day. You're not going to come home from court and see your stuff on the lawn, assuming that everybody follows the laws that they're supposed to. So the general thing to know about the eviction process is that sometimes notice is required, sometimes it's not. Always a court case is required, and then they have to follow up to get a writ, and they have to follow up to call the sheriff. So the whole process from start to finish can take months. I wish I could tell you how long it takes for the sheriff to get to evictions right now, but I don't think that I can. In normal times, I would say 3 to 5 weeks, but we're not really in normal times. A lot of these cases, these 3,000 cases, Matt was right, most of them were dismissals. There were 3,000 cases, and if 25% of them were defaults and folks didn't show, all those folks are going to be ahead of the people who are coming later in terms of when cases are going to be scheduled. So,
Frank, can I jump in on a couple of things?
Mhm.
Just because people don't know what defaults are and they don't know what a writ of restitution is. When you mentioned the process going from a court summons to actually going to court, so let's say someone doesn't show up to court, which Rosie and I will scream into this webinar saying, please always go to court. But say, what does a default judgment mean?
So a default judgment is what happens when you don't show up. So if the landlord shows up and you don't, the landlord will win, period. There are limited circumstances where landlord may not be able to prevail, depending on the case, but it's very, very unlikely for that to happen. The vast majority of these cases are represented, they are handled by attorneys. So most of these attorneys handle these cases in bulk, and therefore will have done most of their homework for all of them ahead of time. So that's really important to know. If you get a case, you got to go, because I can't help you if you're not there. My colleagues can't help you if you're not there, and you can't help yourself if you're not there. So you might have proof of payment. You might have a credit of $5,000 on your rent. It won't matter if you don't show up. So it is really important for people to be there. Right now, the court has largely moved back to in-person for all landlord-tenant cases. For a while, they were permitting Zoom was the default for certain types of cases. A person can move. They can ask the court to appear via Zoom, via what's called a motion, which is really just a request that the court do something for you. But now they've largely moved back. There is still COVID screening. It's if you're vaccinated, it's you can basically just walk right through. So I do encourage people to come.
So from default to the next thing, then what happens?
So if a default happens, all right, and this is a little bit different depending on the type of case, but generally speaking, I'm going to be focusing on failure to pay rent cases, which is the most common type of case that people are dealing with right now. The default happens, and then there's a stay automatically for 4 days. On the 5th day, the landlord can get what's called a writ of restitution or a warrant of restitution or a writ of possession. It's got a bunch of different names, all the same paper. Once they get that, they can call the sheriff to schedule an eviction. A sheriff has to be present when the eviction happens. The sheriff doesn't move your stuff out. They're just there to make sure nobody gets into it with each other. Landlord has to hire movers. Sheriff has to be present. Sometimes the sheriff does only up county on some days and down county on other days. I've been here 6 years. I still don't know what up county and down county actually means. I do know that the sheriff will usually put, we call them red and whites. It's a rectangular piece of red and white paper that will say, this is your final notice of eviction. I will usually tell people to expect to see the sheriff in 48 to 72 hours. That is a little pessimistic. Sometimes they'll take longer than that, but I believe that if that is on your door, then you need to be making plans to go or to pay the amount to redeem it. And a redemption, again, means you, in a failure to pay rent, if the court finds you owe $2,000, you got to pay that $2,000 or leave. So that is failure to pay rents. And we could talk about this all night, but I do want to touch on other topics because there are other types of evictions that I think everyone needs to worry about, or at least be aware of. In addition to the failure to pay rent docket or the failure to pay rent day, there is another landlord-tenant day or docket. In that docket, there are usually 4 types of cases that are heard. There's a breach of lease action, a tenant holding over action, a wrongful detainer action, and a rent escrow action. I'll talk about the rent escrow first and very briefly because this is not a webinar on rent escrow cases, and it is a very fact-specific type of case. Very briefly, the rent escrow action is something that is available to tenants who think that repairs need to be done because their place is suffering from the defects that pose a serious risk to the life, health, or safety of them or their families. So I recommend that if you are interested in that, there are excellent resources online. The Attorney General's office has put out great stuff. People's Law Library has put out an excellent page on it. The short version is that if you petition, if you prevail, the court will allow you to pay your rent into a court account to effectively force repairs to be done. Now, there are other ways for conditions issues to be addressed, which I will again defer to my county counterparts on. I'm not going to talk too much about rent escrow. There's plenty to talk about on it, but today I want to focus on the evictions. So the other 3 cases: breach of lease, tenant holding over, wrongful detainer. Breach of lease is exactly what it sounds like. The landlord is alleging that you, a tenant, have broken the rules, broken the terms of your contract, because that's all a lease is a contract, in a manner that justifies evicting you. That must be a substantial breach that warrants eviction. That's how the statute is written. So, and this is for stuff that isn't about paying rent. So let's say your lease says you cannot smoke cigarettes in your apartment, or your lease says you can only have 3 people in your apartment, or that you can't have a dog, and you have a dog, and you've got 10 people, and you all smoke, including the dog. That's a breach case. They will file a breach case. They're required to give you a certain amount of notice. Normally it's 30 days, although they can do 14 if they can allege that it is a threat to other folks, right? So an example of this would be you kept causing fires in your place, or physical altercations with property managers or other tenants. If those are the allegations, then the notice requirement is a little bit less. The landlord would file that. They'd wait until the notice expires. They'd file the case. The parties would go in. Everyone would give testimony. There's a limited discovery available. And at that point, if the judge finds that A, you did what they said you did, and B, that is a substantial breach that warrants kicking you out on the street, kicking you out of your house, then they will find for the landlord. But there's a lot of things that a landlord needs to prove there. Failure to pay rent cases are very quick. Breach of lease cases can actually take a decent amount of time. Not as much compared to many other types of court actions, but they do require that parties will testify, parties will introduce evidence. There is limited discovery available. There's a little mini trial. So that's a breach of lease action. So if you are seeing accusations regarding your conduct or your housekeeping, it is likely a landlord preparing to file a breach of lease action. If I'm a landlord's attorney, that is not one that I like to use, just because it is a higher bar, but it is sometimes something that they believe is warranted, and they do take advantage of that when they can. That's a breach of lease case. Once the judgment is in place, everything else is the same. Writ of restitution, sheriff, 3 to 5 weeks. Once you get to writ of restitution, there's not a lot really that's different from one to the other. The sheriff doesn't prioritize failure to pay rents over breach cases, as far as I'm aware of. So they, they get the writs, and then they do what they're legally obligated to do. So that's a breach case. Tenant holding over. This is a tricky one. This is already a common one, and it's going to become a lot more common, I expect, in the next 6 months. I think it's really going to peak in September. So a tenant holding over action is what a landlord will file when a tenant holds over past the end of your tenant's lease. So let's say you sign a lease for a year and it ends June 30th. And your landlord tells you in, say, April 1st, that we don't want to renew your lease. They don't give you a reason, or maybe they do give you a reason, but they don't have to give you a reason. But we don't want to renew your lease. We're not going to. Thank you for living here. You are on your way.
Let me interject that has to be a written notice.
Yes, it does. And there are specific requirements for how long it must be. There is language that is required in it, although I will be candid with you. Those notice requirement, the specific language that is required by the county code is not a particularly strong defense for attorneys representing tenants.
But the 60 days notice is.
Right. The time period is, it must be written and the lease must be up. But if the landlord can establish that the notice was proper, that it was written, that it was enough time, that it had the right language, and that your lease is up, that is 9 times out of 10 the entire case. They must show that the lease is up and the notice was proper. Now, there are, as always, exceptions to that rule. There are instances where the eviction or the ejection or the threat to eject or the notice is considered to be illegal retaliation for a protected activity. There are instances where in certain types of subsidized apartments, there are additional things that need to be established for a landlord to kick somebody out under this provision. But the short version is, again, if notice is proper and the lease is up, that is the whole case.
Frank, we're seeing a lot of people who are getting tenant holding over cases that
Yes.
we know are circumvention of the failure to pay rent clause. And they have evidence that is emails or previous filings for failure to pay rent that the landlord is now resorting to a tenant holding over action. And if that can be substantiated in court, are you able to use that as a defense at a tenant holding over action?
We can attempt to do so. The success, I think, will be deeply dependent on each fact. I don't like to get too far into hypotheticals here because it is very, very dependent on the circumstances. And I don't want to make promises to anybody that I can't keep. It is dependent on the judge. It is dependent on opposing counsel. It is dependent on how prepared somebody is when they come in. And frankly, it will be dependent on how these COVID-specific protections change. Because if we get to September and neither of the two that I'll discuss in a minute are in place anymore, I expect judges to be less receptive to that argument than they already are. We've had some limited success with that. Like I said, I can't talk specifics on it, but I will encourage that anyone who faces this type of case reach out to us or reach out to anyone else on this call to discuss the specifics. But it is true we are seeing an uptick in these cases. And we actually saw that last year. As courts started to close up, hear fewer cases, the non-failure to pay rent cases continue to go forward. So I've been in court since last June on other types of landlord-tenant cases. So we were seeing an uptick in these tenant holding over cases because landlords, they knew it's not so much that there was a moratorium, it's that the court wasn't hearing failure to pay rent cases because there's so many people and they were keeping traffic down. So we definitely saw an uptick.
Justice Center, Frank, it's 132% increase this month over last year.
Yeah, I would say that tracks with what I've seen so far. So the tenant holding over statute has always been a difficult one to defend against. We have some tricks up our sleeve, but even with those, it doesn't completely eliminate the advantage that this gives landlords. And frankly, I think it disincentivizes long-term leases. We've had plenty of tenants who have been on month to month for 5, 10, 15, 30 years. So, but that's another webinar. So we've talked about breach, we've talked about failure to pay rent, talked about 10-0ing over, and we've talked briefly about rent escrow. There is one more. It's called a wrongful detainer, or sometimes a forcible entry and detainer, you'll see it called. And it's basically everything else. It is the catch-all. It is the catch-all eviction or removal, might be a better word, proceeding that is available to people who own property. It's not even necessarily landlords. So a wrongful detainer action is based on the assertion by a property owner or by somebody who has the right to possess a property that the person who is currently there, whether they are a tenant or a family member or the previous owner of a place, that's very common, asserting that that person has no legal right to possess a property and never has. So you see instances where, a person, you might have stayed over your lease, but you had a right to be there at one point, and then you were on month to month. That's a 10-0ing over action. If, say, your house was sold at foreclosure and you remain in the property, the new owner may file a forcible entry and detainer case to remove you. Now, I think that that's the improper proceeding, but that's just my opinion on how to read the statute. Courts will use this. Courts will grant this remedy to the landlord. You see it in instances where there are adult children or family members, other family members that are staying, and the situation has devolved, and they want them out. We see it quite a bit with estate cases where maybe somebody let their grandson stay there, and then she unfortunately passed, and now the estate wants to remove the kid. So it's just sort of a catch-all. It is a very unique little action. We don't see a lot of them, but we do see them on occasion. Again, the thing that is different about a forcible entry and detainer is that it says you never had the right to be there at all. Or you never really had the right to be there to possess the property. So those are, in a nutshell, the different types of eviction cases. Again, some of these require notice. 10-0ing over requires notice. Breach requires notice. As of now, failure to parent does not, outside of the complaint. And when I say notice, I mean prior to the filing of the case itself. Failure to parent doesn't, a wrongful detainer doesn't. So, so the question is, what can we do about it? I am obviously biased. I think if you are facing a court proceeding, you should call a lawyer. I don't care if that's an eviction or an arrest or a divorce or a parking ticket. I think if you are facing, maybe a parking ticket, if you are facing a court proceeding of any kind, an eviction proceeding of any kind, you should call a lawyer. The first thing you need to do is make sure that you understand your rights. And maybe that's calling Matt or Rosie and asking them. Maybe it's doing research online. There's a lot of excellent resources out there for tenant education. And then maybe if you get a date, you call legal aid, or you call HPRP, or you call CASA, depending on the circumstances. So that's the first thing you need to do, because the difference in outcomes is staggering, really, really staggering from when somebody is represented to when they are not. We see mistakes all the time. We cover the pro se landlord docket sometimes too, which means we go in and we provide assistance day of to tenants who are facing landlords who are not represented. And it is almost unfair, the advantage that gives us, because we know these rules. We know what the landlord has to do, and we know how to assert it. The judge is not there to assert your rights for you. That is not their job. They are not going to give you legal advice. That is not their job. They're ethically barred from doing so. So call a lawyer, or call somebody else to know your rights. I've talked briefly about how to defend against each specific type of case. Breach cases, you can cure the breach, so stop smoking, or your friends who've been squatting with you leave, or failure to pay rent is you can either demonstrate that you don't know it or pay it and get caught up. All of these cases can be defeated by leaving. They are for possession only. But generally speaking, the best thing that you can do, as far as I am concerned, and then I will hand it off to my colleagues for a moment before I discuss the rest of this, is call a lawyer. Maryland Legal Aid. We're in Rockville. There's a bunch of us. There's never enough of us, but there's a bunch of us and we're working with volunteers. So call us when you get a case, not beforehand, not right beforehand, but when you get a case, when you get a date.
Well, you know, that's a segue for me because the Renters Alliance believes strongly that if you are looking at being behind in your rent, or you are in dispute with your landlord in a way that you can't resolve yourself, contact us early in the process. We will work with you directly. We're kind of like, we're not lawyers, we're not the doctors, so to speak, but we are kind of like the EMTs or the first aid people. And we do know the difference between somebody who needs a Band-Aid and somebody who needs to go to the emergency room. So we're able to take a look at the problem, give you some expert advice, and we also know when it's time to go to the doctor. So, you know, give us a call. Landlord tenant the same way. Rosie McRae Moody's people are available with expert knowledge of this to provide you with information about what your rights are, generally how to handle a situation. Many situations, thankfully, do not require a lawyer. We can tell you how to resolve it. We can tell you how to deal with the landlord. We can unburden legal aid so that they're dealing with the most critical cases. But sometimes there's a time for a lawyer, and many times we will reach out for a lawyer and say, is what we're thinking and advising a tenant the right thing? What do you think about that? And get some advice that way. But then absolutely, at some point, you do need to see a lawyer. Now, Frank, one thing you mentioned about notice, can you explain the difference between getting a court summons and all of those tenants who were receiving notices to vacate from lawyers that look very official?
Yes, I can. So I don't have, I'm bringing forms home with me today, but a court summons is the complaint that is filed with the Montgomery County District Court that says, this is what we are accusing you of, this is your day. So the landlord or any party, really any party, will go and they'll file this, and then it will be served upon a defendant. So in most cases, these are served by mail or by posting on the door. So I'm sure that everybody's seen it. There's a scary looking yellow paper stuck to the door, or sometimes it's white or pink, that says, you know, it has the district court on it, it has all the information for the court, it has some case numbers, dates, lawyer signatures, certificate of service. It's very official looking. That is contrasted with notices, which are really just mean letters. They're just letters. That's all they really are. They're letters that have to say certain things. They need to get there in a certain amount of time. They might be on letterhead from one expensive law firm or another, or from one solo or another, or sometimes just from the landlord. But it is not from the court. If somebody is not sure, for most of these cases, a person can look their name up. So Maryland Case Search is publicly viewable, usually catches up within like a day or two to what has actually been filed. So a tenant can go in and put in their name or their landlord's name sometimes, although for larger buildings that's very difficult, and see if a case has been filed against them. We'll have a case number. However, this is a big however, okay? This does not apply to failure to pay rent cases. Failure to pay rent cases are not viewable on Case Search. So I don't know if you have a case filed against you. I have no way to know. The only way I can find out any information about your case is if you give me your case number, or if you give the court your case number, which is typically in the upper right corner of the document that you've received. If your document doesn't have a case number, and it doesn't have a court seal on it, and it's signed by a lawyer, it comes with a list of demands and sort of a vague timeline instead of an actual court date, then it's probably just a notice. So that notice would have to expire before they can file the summons, which you will get later. Notice first, summons later. Very briefly, failure to pay rent cases, like I said, don't show up online right now. That may change next year. Montgomery County is one of the last jurisdictions in the state to move to MDEC, which is the electronic filing system that's used in basically everywhere except for Baltimore here and want to say Prince George's. They basically started with the small ones first, the smaller jurisdictions first, so they could work out the kinks. So I've heard October. So we might start seeing them viewable in October, but until then, you need your case number, you need the paper file, and if you come to court, you got to bring that paper file with you because I need to see it. I'll move on a little bit on what to expect in court and how to prepare for court in a moment. I'm not sure.
Frank, back on the failure to pay rent and the cures, you mentioned obviously in the breach case, if you're being fined, and this is rare, but if somebody's going to file an eviction notice because you were smoking a cigarette in a non-smoking building, usually they tell you to knock it off. Then if you don't knock it off and it gets a little bit more serious and disputed, they might file. And if they do, the cure would be stop smoking in a non-smoking building or any number of other breaches. But in a failure to pay rent case, the cure has many stages. So obviously the first cure is to pay the rent right then and there, but all the way down to the sheriff. Can you tell us where the cures are?
Right. So for most people, the first notice that they will get of the failure to pay rent action is the actual complaint itself. It'll be the yellow paper stuck to your door. Now, you might have got like a letter from your property manager. It says you've got this balance, you've got that balance, or a call or a knock on the door, or a text from your landlord. But the first official thing you'll get is a complaint. So if that money is paid prior to the actual date of trial, that is good, but it's not enough. Another quick note about failure to pay rent cases is they're only for specific time periods. So today, I worked on 6 or 7 cases in court. All of them, I think without exception, were for March and April, as in last month and the month before, which means that they couldn't go for June, which is still due now. And it means they couldn't necessarily charge for January or February. So this is important because tenants should know exactly what they're being sued on. It's for a specific time period. So you need to make sure that you paid that specific time period and that you come to court anyways. If your landlord says, oh, you're fine, don't go to court, go to court. If their lawyer says, oh, you're fine, don't go to court, go to court. If you hear something from the judge that says you're fine, you don't need to go to court, maybe then you can, head home.
What about the clerk?
So if the clerk says the case has been dismissed, then you don't need to worry about it, because many of these folks will do these dismissals on the day of. And really, I complain about it because it's nice to know ahead of time, but they have so many. The guy today had 300 cases, and so he dismissed them on the record over time.
And what if the lawyer for the landlord, you contact the lawyer for the landlord and they say in writing, we will dismiss? Would you be comfortable with that?
I am usually comfortable with that. As an attorney, I am. I have certainly spoken with tenants who choose to come in anyways, and I fully understand that. If you see in writing it'll be dismissed, then if it's not dismissed, you can certainly file something. It is more paperwork and it is more time out of your day. But I understand. These cases are in the middle of the day during the week, and it's my job to be there. It's not your job to be there. Everyone has other things they need to do. Get your kids to school, go to work yourself. So I understand that. I recommend that everybody come because you just want to get confirmation. And it's also worth noting that in the majority of these cases, you won't get anything in writing. If this case is dismissed, you are not going to get it in writing. So just keep that in mind. I recommend that people go if they can, although I fully understand if people have other obligations in their life. So, but if you get something in writing from the lawyer saying it's dismissed, you don't need to come in, that lawyer would be in some serious trouble with the judge if they went and changed their mind later on. I'll leave it at that. And I can't think of any of the counsel that I practice across from regularly who would try to pull that. None of them would even consider it, I don't think.
So the other cures in failure to pay rent?
You could leave. That's number one. Remember, a failure to pay rent action is for possession. So if somebody leaves, and when I say leave, I mean you leave and your stuff leaves and your keys go back to your landlord. That is an option. It's an option for a lot of people. I understand it doesn't work for many others, but There are some folks who the situation is deteriorated and somebody no longer wants to live somewhere anyways, so they will vacate prior to court. And if you vacate prior to court, you should still show up. You should still tell the judge, I left on this day. I gave my keys to, John Doe. So paying ahead of time avoids a judgment. Leaving ahead of time avoids a judgment. It's worth noting that judgments, while they are certainly something to be avoided in failure to pay rent cases, are not fatal to somebody's credit. More often than not, they won't show up on credit reports. They will show up on rent history reports, but they are not as crippling to somebody's situation as many believe that they are. I
So
still
you get-
encourage everyone to avoid
So
them.
you get a judgment against, you haven't paid the rent, the writ of restitution is filed. When else can you cure?
So my understanding is that the sheriff's policy is that if the rent is paid, if the property is redeemed, anytime before the sheriff shows up, they will not do an eviction. So this is something that I mentioned at the beginning. This is a hyper-local field. This is the Montgomery County Sheriff's, I believe, unwritten policy, is that if it is paid beforehand, the sheriff does not like to do evictions. They don't like it. And I don't blame them. And frankly, many landlords don't like doing evictions. It costs money. So if you can pay anytime until the sheriff shows up, you will redeem it. You'll still have the judgment, but it won't really mean anything. It will, because if you have 3 within the last year, you won't be able to pay and stay again, which is important to note. It's another reason to avoid a judgment. Again, the thing about a failure to pay rent judgment is it's not for money. It's just for possession. It is something to be avoided when you can, but it is not going to crater somebody's credit for the rest of their life.
Frank, let's emphasize the 3 and 12 scenario. What is that again?
So a person has what's called the right of redemption when they lose a failure to pay rent case. And sometimes you'll see right of redemption in the context of a foreclosure as well, but we're talking about it with evictions. So the court finds that some amount is owed, $2,000, $3,000, $5. Lowest I've ever seen is $12.50. At any time before the sheriff shows up, the tenant can pay that amount to the landlord, and the landlord is required to accept it, and the landlord cannot proceed with an eviction. It is called the right of redemption, not the option of redemption, not the would like to encourage everyone to redeem the property. It is a right of redemption. It's a right you've got. Now, if you have 3 judgments against you, failure to pay rent judgments within the last year, I believe it is 3. Double check that.
Last 12 months.
3 in the last 12 months, which right now is sort of all over the place because we've had a year's worth of cases in the last 2 months. Then the landlord can request that right be it's foreclosed. So it's a box that they have to check. They have to ask for it. They need to show that they have judgments. And then if they can do that, if they choose to do that, you no longer have that option available to you. You can no longer pay and stay. Got to go.
And that's on the 4th filing, right?
Yes. And there is a specific section in the complaint that must be checked. Case numbers must be provided. And it is from the date of filing. So cases that were filed in, say, December that we only heard 3 weeks ago, that clock runs from last December, not from now, which was actually a really important distinction in a lot of the cases that we dealt with because of the way that the court scheduled everything.
And also the foreclosure that is on the 4th filing is not automatic. It's up to the landlord.
Right. They need to request it. Exactly. So many landlords just would prefer to get paid. Some would prefer to get you out. It really depends on the situation, their situation, your situation, your relationship between the two of them, or the relationship between the parties. So, and frequently how much rent is actually owed. Because unfortunately, we're seeing numbers that are, some are only 2 or 3, which is a really high bar for a lot of folks, but some are 5,000, 10,000, 15, 20, 30. We had one the other day that we took care of, thankfully, but they were seeking $90,000. And it's just, and then you have the commercial cases, which are a whole other kettle of fish. Anyways, sometimes landlords will not want a party to redeem. They just want somebody out so they can get somebody else in. Or their relationship has just gone completely south and they just want somebody out, period. They don't care if they get in. So that's really most of the sort of off ramps for a failure to pay rent case. There are other defenses. Technically, and I say technically for a reason, a party can raise a rent escrow action as a defense in a failure to pay rent case. That is something that is legally permitted under the statute. It is a bad idea. It is a bad, bad, bad idea because it is putting you in a position where if you lose your house. If you want to file a rent escrow case, do it affirmatively. I have this argument with counsel and with judges all the time. It is a bad idea to do it this way. If you want to file a rent escrow case, do it affirmatively because the court is probably not going to hear it in a failure to pay rent case.
What do you mean by affirmatively, Frank?
Go sue your landlord on a rent escrow case. Go file a case against them so you are the plaintiff, they are the defendant, rather than trying to use it as a counterclaim or as a defense in something where your housing is on the line. It's just, this is an instance where I am giving you my opinion based on my experience as an attorney. The statute says you can raise it. I'm telling you it's a bad idea and you shouldn't do it if you have any other options, and you do have other options. So rent escrow cases can be raised. Sometimes the amount can be chipped down. So you can show that you paid this or you paid that, or this is actually for the water bill or this is for the parking. We recommend that you speak with either Matt or Rosie ahead of time, or you speak to us in court to try and get to an amount that's actually owed. And then you can maybe try to get some from the county or from nonprofits or friends and family, or if you have some savings.
And let me interject on rent escrow. Rent escrow means I have the money. I'm not going to pay it to you because you haven't fixed something. So if you go to court and you raise that as a defense and the judge says, well, you still going to have to pay the rent. If you don't have it, you lose. So don't file rent escrow thinking you're not going to owe this money, because you probably are going to owe it. Even if you win, you're probably going to owe some of it. Even if it's not all of it, you'll probably owe something.
And most judges will require that tenants pay that full amount into the court's escrow account like that day or a day later. So if you haven't paid rent in 6 months, do you have 6 months of rent in your bank account? I mean, maybe you do. Some people do. That's great. Most people don't.
Yeah.
Most people don't. So if you file ahead of time, you pay your rent as it comes due, which is more manageable for most people. It is worth noting that I know that many viewers here or people who will be viewing this later might have housing choice vouchers with either HOC or Rockville Housing. That can get very thorny sometimes in terms of who owes what portion, and is a rent escrow actually worth it if your portion is only, say, $20 a month? How coercive is that really going to be for a landlord, as opposed to HOC abating the property and not paying their, $14.80 a month or whatever. So, but again, rent escrow cases, as I said, they're very fact specific. I can't get into all the hypotheticals on that now. That's really most of the off ramps. 2 quick notes. A party can request or can demand a jury trial in a failure to pay rent case. Frequently, it will require what's called a bond, a supersedis bond, to stay eviction. So at the end of the day, the bar is you need to pay your rent in order to avail yourself of the failure to pay rent jury demand. And the other option that is available to some parties is an appeal. Most of these cases are what are called de novo appeals, which is just like a redo on the case, except it's across the street in Silver Spring or in Circuit Court. Again, that also requires a bond. So sometimes with a failure to pay rent case, the bar is you either have to pay the rent ahead of time and not have the case against you at all, or appeal it and then pay the rent anyways, or you face an eviction even if you have an appeal going. Again, really specific to the case. I won't get too far into the details on that, but that's another, I suppose you could call it a way to cure an FTPR ahead of time.
Let me also remind everybody who's listening that you can put your questions in the chat. We will get to them. One question that's come up, Frank or Rosie, or Frank Desmarais, if you're listening, and maybe you can answer this. The eviction orders have placed a certain restriction on evictions and failure to pay rents that come to court. But are the judges giving a judgment against And if it's a judgment against, does it count as one of the three? Or does it have a different status? Is it
Yeah.
count as a dismissal or as a delay? What is the nature of that?
So, in September, Governor Hogan's eviction order, which requires that a tenant be able to show via documents or other objectively verifiable information that they lost income as a result of COVID for a couple different reasons, but it requires a showing in court with evidence. That was issued last summer. And the chief judge for the district courts, Judge Morrissey, issued some guidance on it, and then our local court did as well. The local court issued the guidance on it, and then I believe 8 hours later, the CDC moratorium was put into effect for the first time. So we're largely just using that first administrative order for everything, including the CDC. Here's the way it works. And it's a little contrived, but it does work the way it's supposed to. If a person asserts either Governor Hogan's order or the CDC order as a defense in a landlord-tenant case, or in a failure to pay rent case specifically, the court will find that some amount of rent is owed, let's say $2,000, but they will reserve the judgment until a later date. Now, here's what that's not. It's not a judgment day of, and it's certainly not a dismissal. It is not a judgment with a pause. It's not a judgment that they can't do anything with until later. It's nothing until July 1st. The vast majority of these cases are CDC declarations for a couple of good reasons. The CDC is set to expire on June 30th. I do not expect it will be renewed, although I have been wrong on that before, and I hope to be wrong again. On July 1st, that will expire, and all of those cases that were reserved for judgment for a later date, judgment will be entered on that date. So here's what that means. If you've got a CDC reservation and you pay your rent after court, but before July 1st, it's kind of like you paid before court because that judgment is never actually entered. If you leave after court, but before July 1st, it's like you left before court. And it's like the case never happened. It's dismissed. Now, this is going to be extremely tricky in practice because my understanding is that the court is going to do these automatically. So I would strongly advise all tenants that if you make a payment that covers the amount that the judge finds owed, you have to keep track of it. You have to keep proof of it. I know that this is really, really difficult for some folks who pay in cash, but you need to take every step that you can to document payments that you've made. Demand a receipt. It's your right under the law for a cash payment. Pay in money orders, and for the love of God, keep your tracking information. Check or cashier's check, same thing. If you don't have proof that your payment was made, I can't prove you made a payment. So you need to make sure that you do that. So again, if you pay after the CDC reservation was entered in court, but before it expires, it effectively goes away. Matt's put something in chat. You have to come to court to assert these. You have to come to court to assert these. I have been heartened because there's actually a number of landlords' attorneys that are doing this on their own. They're saying, oh, my client told me that this tenant gave CDC. So they will say it there on their own. Now, not everyone's going to do that. I think most of them do now, but not everyone's going to. And there's also a disconnect because maybe the landlord didn't tell their lawyer, or maybe they did, but it got lost in the spam filter, or maybe they lost it themselves. So I really recommend that you come in and assert it. I generally will have you fill in a new one right there, give it to the landlord in open court, and that's it. Yeah, so I recommend that people come in, as always, to assert that defense, even if you've done it before. But it does require that somebody come in.
Well, let me just say something, and maybe Rosie, you can back me up by saying it again. As a reminder to all tenants out there, your relationship to your landlord is a business relationship. It is guided by a contract, as Frank pointed out. A lease is a contract. It's a legal document that is an agreement between two parties, a legally binding document between two parties. But every other communication between you and your landlord needs to be thought of in business terms. Now, you may be friendly with your property manager. They may have been nice to you for years until suddenly you need something, or you didn't get a repair, or you didn't pay your rent, or you're late, or something like that. If you don't keep track of these things, then you're on a handshake basis, which inevitably ends up in confusion and your inability to prove what you've done. So you should get a receipt for your rent. If you have a complaint that you said verbally down to the maintenance office, you need to follow up with an email or some written document that says, I called and said my refrigerator is broken and I'm looking forward to you coming on Wednesday like you promised. Keeping track of a business relationship, because when the business relationship goes south or becomes sour, you're going to need evidence in order to back up where your position. So, in everything, not just evictions, not just the most serious things, but on everyday relationship with your landlord, generally you should back up anything verbal in writing if it's important. Am I right, Rosie?
Yes, you are.
Thank you.
And we always encourage people to put everything in writing. So whatever goes on between you and the landlord, send an email. He should keep track and you should keep track too.
This actually segues nicely into the next thing I want to talk about. Very briefly, we're in court. We're there. We're there to provide day of assistance. We can't cover every day. We don't have all the people for that. We were able to do it for the last 2 months. We've had to move some resources around, but we will be there. If you call us, we will try to help you if we can, if you're eligible. I'm not going to go into the specifics of eligibility. If you wonder if you qualify for Maryland Legal Aid, go to our website, mdlab.org, Michael Delta Lima Alpha Bravo.org. And our numbers are there. When you call us or when you come to court, you have to be ready, because I don't know anything about your case except for what you tell me. I have no secret documents. I have no lawyer tricks to pull your proof of payment from the bank. I will depend on you to give me what I need to defend your rights. So if you documented that you paid your rent, or you documented that you wanted them to come fix the fridge, I need to see that. If you lost income as a result of COVID, if you had to stay home with your kids because the school shut down, you got a letter from the school saying, I'm sorry, we're sending your kid home, or I'm sorry, we're shutting the restaurant down, or I'm sorry, we have to lay you off. I need to see that. If your unemployment got cut, I need to see that. So make sure that you have these documents with you. And if you're going to come to court and ask for our assistance the day of, we will do our best to help you. But boy, is it helpful if you're organized and ready to go when you get there. Multiple copies of each paper is great. Having it ready to go, being ready to talk to us, understanding what your timeline is, bringing your lease with you, that is all really, really vital, because it's really difficult to help without documents.
Sorry to interrupt, Frank, but if you didn't get that letter from your employer, then get one. Ask your employer to write you a letter saying we had to lay you off because we didn't have enough hours. If you're having trouble getting documents, then call us and we'll help you get those documents. But don't say, hey, don't throw your hands up in the air. There are ways to prepare, and sometimes you have to be proactive about it.
We talked about most of this. One of the last things I want to talk about is when you should seek a lawyer. I agree with Matt and Rosie. I'm the emergency room. By the time you get to me, your chances aren't necessarily as good as if you'd gone to the doctor at a time. So, try to talk to them. And sometimes all you need to do is talk to your landlord. This is certainly not going to be the case in every situation, but especially with smaller landlords, I believe that they are feeling financial pressures as well. I don't necessarily think that they should be passing them on to their tenants in the way that some people need to do. However, work with them to get the help that you both need. It solves more cases. I am able to settle the majority of my cases because what I can do is go to the lawyer and say, look, I know these two folks hate each other, but let's fix this problem. So try to fix it before you come to me.
let me just address one thing in here if I think I understand what the person is saying. If you're late and never received a judgment, basically, there is no judgment if you have not received a court summons to go to court. If you were late with your rent and your landlord says you were late, but you paid your rent and probably had to pay a late fee, which is, Rosie, if I'm right, it's 3%, 5% of your rent after the 10th of the month. They can't charge you a late fee until after the 10th of the month, no more than 5% of your rent. If you paid both of that and it was just a threat from your landlord, then there's no judgment because you haven't gone to court. There's no court summons that says show up. And then if you don't show up, there's a judgment against you, or you do show up and you haven't paid your rent, then the judge might give a judgment against you. If none of that has happened in the court, there is no judgment against you. You were just late and you paid your landlord and paid whatever fine there might have been from the landlord, no more than 5% of your rent. Frank Vitale, thank you very much for all of this incredible information. I should also throw in, Frank, that if you don't qualify for a legal aid attorney, sometimes the Renters Alliance and our allies can look for pro bono attorneys or low-cost attorneys for you. Sometimes we can just get some legal advice for you that might solve a particular part of your problem. Frank Vitale, I do believe that CASA is also in the courts helping you. The Homeless Representation Project, Homeless Persons Representation Project is also helping you. The Public Justice Center in other parts of the state are helping. Anybody I left out?
No, that's so in Montgomery County, that's most of it. You know, we have different versions of this program. We're sort of developing it as we need to, depending on where we are. CASA has been, and I really should have led with that. Our legal partners are CASA and the Homeless Persons Representation Project. John Marshall was scheduled to be here, but he actually let me know he had an emergency come up. He wasn't able to. But they are there. They're able to cover certain types of cases that we can't. And without their cooperation, we wouldn't have been able to do any of this. I would have thrown myself at a bus by like the third week of April without their help. So it's really, really important to know that it's not just us. We've also had folks from the Housing Initiative Partnership and LEDC, Latino Economic Development Corporation, I believe,
right,
who came in and provided assistance day of. Renters Alliance assisted with outreach. The county's been a great help in helping get people prepared for court. So,
but
yeah, we're not the only town.
Those other organizations, Frank, don't have your eligibility requirements on day of. Is that right?
They have some eligibility requirements. CASA, I say CASA is a law firm. It's one housing lawyer, and he's great. But it's just one guy. And HPRP, we are law firms, and we're still law firms. So we still have to worry about conflicts of interest. We still have to worry about case priorities. But generally speaking, I can't think of an instance, or I can think of very limited instances where somebody's come in and someone hasn't been able to help.
All right. Well, anyway, thank you very much, Frank Vitale from Maryland's Legal Aid, supervising attorney here in Montgomery County, doing yeoman's work in a very difficult period. And we thank you for your information. Please contact us if you need some help with legal aid. We'll direct you to the right place. And they are available in court on the day, and they can find you in court. There are signs everywhere. Is that my understanding, Frank?
There's no signs anymore because we're only in one room. So look for someone in a suit and ask them for legal aid, or ask the bailiff. Actually, the bailiffs know who we are. And I think, with very limited exceptions, the judges will let you know that we're here too. So we're not that hard to find. We're not that hard to find.
All right. Well,
we usually have 2 or 3 folks there at a time.
Thank you very much for your presentation, Frank. Much appreciated. We're going to now move to a little bit of a discussion very briefly on the COVID rent relief program. The COVID rent relief program officers are literally working as we speak to process applications and get checks out the door. I do have some information from the supervisor, and she wanted me to relate this to you. So let me tell you just a couple of things. The application, this program is open. But if you applied for the earlier programs and did not reapply, you have to reapply again. I put the link in the chat. I'll put it in again. But if you applied back in December and you haven't heard back, then you didn't get a check, and you're not going to get a check from that program. That program ran out of money. They spent all that they could. You need to reapply to the most recent COVID rent relief program, which is open now. They have received over 7,000 applications. They have only processed 1,100 of them so far. And there are 200 that are under review as we speak. So they are asking for your patience. It may take weeks or months to get a check out the door, but there is a tracking program you should have received when you submit your application, a confirmation email that says that they have received your application. You should be able to check to see the status of your application, whether it has been assigned to a caseworker or not. And unfortunately, that's about as far as the tracking goes at this point. Otherwise, you're kind of in limbo, but you need to take that confirmation email from your computer and give it to your landlord, or take it with you to court to show that you've done everything you can to apply for this program. Now, one other thing I do know, that if your situation changes, say you applied because you received a court summons and the summons is in June or July or now, and you've gone to court and it was a judgment against, but your eviction is delayed because of the eviction order. You're in a certain status now. But say you get reapplied again, or the landlord moves in some way to demand a writ of restitution, where now you're going to move more seriously towards eviction. We need to know that, and so does HHS. So if your situation becomes more dire, beyond being in the failure to pay rent process that is not facing eviction immediately, then let us know so we can help get you prioritized. Unfortunately, that is the nature of the program now. And as I understand it also, and Frank Desmarais, if you're listening and I'm wrong, please chime in. But it's once you're in the process and you put in your application, if new information becomes available to you, like you're now facing eviction and because you've received a writ of restitution and the sheriff is coming, the application process doesn't allow you to upload that new information. So we are urging you all to make sure that you've applied, to track where your status, to be patient, to understand that they're dealing with almost more than 7,000 applications, and they've only gotten to 1,100 of them so far. They need to, obviously, in fairness to a competent and bureaucratic process, they got to make sure we're going to give people upwards of $12,000, that they are who they say they are, that there is an actual need, that the landlord is on board, and so on. So it does take a little bit of time for each caseworker to work through these, and they are trying to work as fast as they can. And the Renters Alliance is working with you to help them work as fast as they can, we promise, but we can only do so much. So they are asking for your patience. With that, let me turn it to Rosie McCray Moody, the manager of the Office of Landlord and Tenant Affairs, and to Keen Nichols, a supervisor at Code Enforcement, to give a little brief update on what they do, what they're seeing, and any reminders about what they think is important. Rosie, Keen?
Hello. Landlord tenant is there to help mediate disputes between landlords and tenants. People are starting to move now, so we're starting to get more complaints about security deposits. But if you have questions, please call 311. We have someone on duty every day from 8 to 5 to answer any questions, and we will call you back. We have one of the best callback rates in the county, so we will call you back. We usually call you back the same day. And if we get back to you and you're not there, you'll leave a message. We will get back to you. We'll call you at least 4 times before we give up. What Frank Vitale has told you is your best advice. Go to court. If you've been sued, go to court. If you owe back money, apply to HHS. I know it's frustrating, and I know you're impatient and you're nervous, but the process is what it is, and you just have to be patient and, kind of trudge through it. Because HHS does have that money, and that's basically about the only way you're gonna get $12,000 is if they give it to you.
Rosie, can you talk about the rent cap, where it stands?
The emergency legislation passed last year said that a landlord could not raise rents more than the voluntary rent guideline. And last year it was 2.6, but as of February 5th, it was 1.4%. So no matter what, if it's month to month, annual, year to year, 2-year lease, that rent increase cannot be more than 1.4%. Up until the emergency is lifted. And at this point, the governor has not done that. And even when he does, they still can't raise the rent for at least 90 days after that. And then they'd have to give you 90 days notice. So your rent still can't go up more than the voluntary rent guideline until 181 days after the emergency is lifted.
Rosie, or Frank Vitale, but Rosie could probably answer this. It's a question in the chat. You're behind in your rent. You haven't received a judgment against you yet. You haven't been evicted yet. But say the landlord says, you know what, because you're behind and I'm going after you for rent, but I haven't evicted you yet. The court hasn't ordered the eviction yet, but I'm going to take away your parking space. Can they do that?
It depends on what your lease says.
Really?
If you have a parking addendum that says your rent has to be current to retain your space, then they've told you that, and then they can do it. But if there's nothing in your lease or in your parking addendum, if there's nothing in the rules of the property that says if your rent isn't current, I'm gonna keep your space, I'm not sure they can do that.
Yeah, it's called a willful diminution in services is the official legal term. So you normally see it with like, oh, they turned off my electric or they turned off my gas or, something like that. I would say that that's accurate. The lease is going to be the governing thing in most of these. Now, unfortunately, if they do tow your car and say you can't park there anymore, a lot of this comes down to how can you enforce your rights? Because I'll tell you, if you come to me and you say, Frank, I want to sue them to get my parking spot back, the best answer I can give you is, okay, well, we'll file a case, and I hope you have somewhere to keep your car for the next 6 months before we get a court date. So, I think on that, I would make sure that you understand the terms of your lease before anything else. Sometimes they can, and unfortunately, enforcement mechanisms in the district court are slow.
Well, I think it's.
And you can call landlord tenant, we'll try, but we can't promise you that we can do anything either.
But here's a scenario, maybe that's a splitting hairs thing for someone that has a JG. But what happens if your lease says your parking is $115 and your rent is $1,800? You can't pay your $1,800, but you can pay your parking fee. Can they refuse to accept it, or can they accept it and not reduce your parking space while they're still facing a failure to pay rent?
I mean, if you pay your $115 a month, that's going to be kind of dependent on the facts and how you make your payments. I think that if you paid with a personal check and in the memo line you put parking May or parking June or whatever, I think you would have you built yourself a fairly solid record for a case that you would want to bring regarding your parking. So let's say that you get your car towed, and so you have to rent a car for a couple of days, and you get paid to get your car out. That's a small claims case. You file a case against your landlord saying you illegally towed my car, and these are the damages that I incurred, and you illegally towed it because I was paying, and look at all my receipts. That's all great, but at the end of the day, you've got that FTPR in the background too. So they're kind of in tension, unfortunately. But
there's an important theory here, or operating theory, that I want to make sure tenants understand. That if you are behind in your rent or some other objection from the landlord, but you have not been evicted, the landlord cannot diminish your promised or required services. They can't lock your mailbox. They can't lock you out of your apartment. They can't turn off your, and Frank, interrupt me if and when I'm wrong. They can't turn off your electricity. They can't turn off cut your cable. They can't do anything to diminish your services or invade your privacy or do anything to you until there is a court order that allows them to do that. Is that accurate?
Yes, on a continuum. You know, if your electric is turned off, that is a major problem. If your heat is turned off, that is a major problem. If your locks are changed, call the police, because that's a major problem. You know, you sort of run into district court can be a little bit less formal than circuit court can, and you know, that's not always a bad thing. But sometimes if a landlord turns off cable, maybe that will not be treated quite as seriously as turning off the electric. But generally, yes. Generally, what you're talking about is either a diminution in services or a constructive eviction, depending on how far it goes. Sometimes it constitutes a retaliatory action. We've dealt with a number of these cases. It is really fact specific. And I'm going to give you the most lawyerly answer is it really depends on the situation. So generally speaking, yes.
Because you can't, the landlord cannot deprive you of a required service. You have to have water, you have to have gas, you have to have electric, you have to have doors that lock. So he cannot stop any of those things. And parking is not a requirement. Cable is not a requirement, and those get kind of sticky, but your required services, he cannot stop. He cannot cut off the water because you're behind in rent. He cannot cut off the electricity because you're behind in rent. He cannot cut off the gas because you're behind in rent.
And if you have any of these problems, please let us know. We deal with landlords who really often just don't understand what the law is, and property managers in the first place.
And call code enforcement will demand that it be turned back on immediately
for utilities and so on.
Yeah.
And Keen Nichols, what's going on with code enforcement these days? We know that you've had to be careful during the pandemic. What's the status now? What are you seeing?
Hello, everyone. So the our group is been for the last 14 months focusing on handling complaints and also the exterior code violations. We are poised. We don't actually have the firm date, but it's very soon where our inspectors will be going back into the units. Again, we don't have that date yet, but during this whole time with the pandemic, our team has been reaching out to property managers to the extent possible to make interior inspections on an emergency basis. And of course, those interior inspections where it was not an emergency, we were conducting via FaceTime or some type of video chat or receiving photos. We do have a backlog of inspections from our mandated inspection program. Don't have the final number of what that is, but our staff is raring to go. We're in the process of lining up a schedule to get through that backlog. And yeah, COVID threw us all a monkey wrench, but we have systems in place. So once we get the green light to be back in the units, we will encourage folks, as we have been throughout the pandemic. If you've got a complaint, please do so. Send us that information. There is one of the issues that we're getting a lot of right now, and encourage you to give us a call, is because we've got some more aggressive timelines associated with our enforcement of AC and the new bill that was passed, and a new executive regulation that stipulates the short turnaround times for the AC repair. So if you've got issues with your AC, a lot of property owners don't. And of course, this past month, it's been cold and it's been warm and it's been kind of crazy, but typically they turn them over May 15th, some sooner, some later. All
now says June 1st to
right.
September 30th.
September 30th. Yeah. So right now they actually have to have AC. So if your building is not switched over, or if your building does not have AC, definitely let us know. Obviously, if it's broken, let us know. We will make sure it gets fixed.
Rosie or Keen, could one of you please explain the difference between your two departments? I've just put the links to the complaint processes for both of your departments, but please remind everybody the difference and where they should go.
If you
Sure.
have a problem with the landlord not respecting something in your lease, not enforcing your rights, not giving you back your security deposit, that's landlord tenant. If you have mice, your sink is leaking, your floor
Compliance.
creaks when you walk, that's code enforcement.
Yeah, so the easy distinction is like if there is something that's broken in your apartment, that's code enforcement. The physical, tangible, nuts and bolts, walls, appliances, any of that stuff that is not working, that's code enforcement. Anything
If you've
else?
got a court date, it's legal aid.
Right. But somebody just put in, if an appliance over a 6-year period needs work, that eventually breaks down, can a tenant ask for a new appliance instead of a used one?
Well,
They can ask for it, but there's nothing, they have to have an appliance that works.
Yeah.
If I take out the 6-year-old one and give you another one, even if it's not brand new, if it works, then I've satisfied the law.
Has to be in good working order. That's the only thing that's required. I also throw in, just for the sake of fun, you are entitled to have your apartment painted once every 5 years if you request it. So a lot of people don't know that, but it's not the same thing with rugs. They don't have to replace your rugs every 5 years. So the Renters
But
Alliance,
the average life of carpet is 7 years. So if you stay somewhere 10 years and you ruin the rug, they can't charge you for it.
but they also don't have to replace it because you don't like it anymore. Is that right?
They have to replace it if it becomes a hazard. So if it's wall to wall and then it's ripped up in a spot so that it's a tripping hazard, then code can require that you change it.
All right. Then I think we may have run the course of this particular renter town hall. I want to, again, I put in the chat the 2 links, one to the Office of Landlord and Tenant Affairs, which handles complaints about your rights and your lease and so on, and the Code Enforcement Department, which has anything that's broken, and mice and vermin infestations, cockroaches and so on. That's code enforcement. Frank Vitale and his partnership with CASA and with the Homeless Persons Representation Project have lawyers in court on the day of, reminding everybody to please think about Judge Judy. What would you need if you went to court? What would you need to prove your case? Get those documents together. Remember that you have a business relationship with your landlord. Don't be lulled into thinking you all are just pals until things go south and there's a problem and you wish you had only gotten a receipt for your rent, or you wish you had to put that in writing and now the landlord is saying something completely different from what he or she told you before. Don't get into that situation. If you have to go to court, go to court. Do not miss that court date. If you're confused, landlord tenant, Office of Landlord Tenant at 311, the Renters Alliance at info@rentersalliance.org is here to help you, will guide you, will point you in the right direction with expert advice, and if necessary, prepare you to speak to the jurist doctors, the lawyers who are in court. Okay, so with that, I want to thank everybody, particularly Frank Vitale, Rosie McCray Moody, Keen Nichols at Code Enforcement, Frank Demaray, who's listening, I know, and Chris Perry on my board, our vice chair, who's also listening and gives me great support and advice in between these calls and sometimes on them. So thank you to all of you. It's 8:30 and good night.